All right, this is it. The last full stretch. For this recorded session, we will be discussing about defective contracts as well as natural obligations. So without further ado, let's get right onto it. Defective contracts are governed by Articles 1380 to 1422 of the new Civil Code. Now, of course, we can distinguish or categorize contracts according to their validity. A contract is either valid, basically one where consent, object, and cause are all present, all of the essential requisites are there, and without any defects affecting the validity of the contract in any way. Pulidong kontrata, maayos na kasunduan. Nothing is wrong. This contract has been properly negotiated upon, properly perfected. A valid offer meets a valid acceptance, and there is meeting of the minds. Thereafter, there would be nothing left to do really but to consummate the contract. All is good. So that is a valid contract. On the other hand, we also have defective contracts. So yan ang pag-uusapan natin dito sa session na ito. Now, there are 4 kinds of defective contracts. We have rescissible contracts, we have voidable contracts, we have unenforceable contracts, and we have void contracts. What you're seeing in your screen right now is a comparative table we have come up with comparing these 4 kinds of defective contracts. As we will be going through the provisions of the new Civil Code, mas magiging malinaw sa inyo kung ano ba itong mga material differences that set, for example, a void contract apart from the other kinds of defective contracts. Now, let us move onward and discuss rescissible contracts. A contract is rescissible if it contains all of the essential requisites of a contract, which make it valid, yet may be rescinded. So let us pause right there. The word rescissible, ang root word niya ay rescind. You may or may not have noticed that we have already discussed a little something called rescission in our previous lectures. So all right, tuloy tayo ulit. So this rescissible contract is an otherwise valid contract. All of the essential requisites for a valid contract are present. However, what differentiates a rescissible contract from a valid contract is that a rescissible contract may be rescinded. For what reason? By reason of injury or damage to either contracting party or a third person. So merong element of injury, merong damage, yung tinatawag nating lesion to either of the contracting parties or to a party outside the contract, yung third person. Now, rescission in this context creates the obligation to return the thing itself, which was the object of the contract, together with its fruits, if any, as well as the price with its interest, again, if any. So what are other characteristics of rescission? Again, in this context, rescission in the context of rescissible contracts can be carried out only when the party who demands rescission can return whatever he may be obliged to restore. So merong implicit requirement na in order for you to demand rescission, the rescission of a rescissible contract. Kasi syempre rescission. What is rescission? Parang nagsasaulian kayo ng kandila. So kinakailangan para mag-demand ka na the other party return whatever it is that you gave him or her, kailangan yung naibigay ng other party sa'yo, kaya mo ring ibalik. All right? That's the implicit rule here. Rescission shall not also take place when the things which are the object of the contract are legally in the possession of third persons who did not act in bad faith. Pwedeng mangyari na yung object or yung thing na ibinigay mo doon sa other party to the contract naibenta na niya o na-donate sa iba. Ngayon, itong third person na to, in all likelihood, wala naman siyang idea na rescissible pala yung kontrata ninyo. Alright? In the first place, third person siya. Hindi siya privy sa anumang pinag-usapan ninyo ni other party. Alright? Now, without any knowledge of anything illegal or anything wrong, pinoprotektahan ng batas yung possession ni third person. Yung tinatawag nating innocent purchaser, for example, in a contract of sale, innocent purchaser in good faith. This person has no idea that there is anything amiss or illegal with regard to the previous transaction. Innocent nga eh. He or she acquired this thing in good faith. And therefore, hindi pa pwedeng basta-basta bawiin sa kanya yung nabili niya o yung idinonate o ibinigay sa kanya. Kasi hindi naman niya alam na nanggaling pala yun sa rescissible na transaction. So what then would be the remedy of the aggrieved party? Damages na lang. An action for damages can be instituted instead against the person causing the loss. Now, the person, on the other hand, who acquires the thing in bad faith shall indemnify the creditor for damages where due to any cause, it becomes impossible to return the thing. For example, si third person, alam niya na merong something questionable doon sa transaction ninyong dalawa ni other party. This issue or this problem would make the contract rescissible. So alam ni third person yun, alam niya na mayroong something irregular. But still, he or she gain possession of the thing. For example, binili niya doon kay other party. Knowing the irregularity nga. Now, sabihin natin na iwala ni third person or nasira niya yung thing. Hindi na maibabalik. Ano ngayon ang remedyo ni aggrieved party? Damages, no? The third person who acquires the thing in bad faith, aware siya doon sa irregularity, doon sa unlawfulness ng exchange o ng transaction. That person can be held liable for damages in favor of the aggrieved party. Of course, provided that it is impossible at that point to return the thing. Kasi kung pwede pa rin kunin, kung nandiyan pa rin yung thing, di syempre yun ang dapat ibalik. Where there are two or more alienations, the first acquirer shall be liable first and so on and so forth. Kasi pwedeng naipasa-pasa na in a series of transactions yung object. So of course, you have to pursue them in sequence. You first pursue the first person who acquired the thing, and then the second one, and then the third, and so on and so forth. Rescission, of course, shall only be to the extent necessary to cover the damages caused. Rescission is also a subsidiary remedy. That's not a principal remedy. Ibig sabihin, kung meron pang ibang action in order for the aggrieved party to enforce or vindicate his or her rights by virtue of the contract. Like for example, a specific performance, no? O di kaya naman some other action. Rescission is a remedy of last resort in this context. All right? Now, for how long can an action for rescission be filed? The law provides that the prescriptive period for the filing of an action for rescission is 4 years from the date of the contract. Now, the 4-year period, hindi siya mag-uumpisa from this date of the contract for persons under guardianship, yung mga minor de edad o yung mga may problema sa pag-iisip of unsound mind, no? Na mayroong mga tao na other people handling their affairs. In other words, guardians. Like for example, a minor, once na he or she turns 18, the incapacity on his end, on his or her end, caused by his or her minority, mataterminate yan once this kid turns 18. So, if the other party is a minor, or if the aggrieved party is a minor, hindi from the date of the contract yung bilang ng 4 years, kundi from the 18th birthday of the minor. Once na maging 18 siya, tatakbo yung 4 years. Now, for absentees, all right, the other party, nararamdaman niya na baka magfa-file si aggrieved party ng action for rescission, nagtago, nawala. So, syempre, in order for you to be able to file a case against another person, you need to know that other person's address or residence. Kasi doon ipapadala ng court yung mga court orders, mga notices. Hindi pa pwedeng hindi alam ni court yung address. So, if the other party is effectively an absentee, hindi tatakbo yung 4 years. Tatakbo lang yung 4 years once the domicile or the residence, interchangeable siya yung dalawang words na yun in this context, in other legal matters like, say, how do we say this? No? Election, magkaiba ang import ng mga terms na yan. But for our purposes, no? Once the domicile, once the address, once the residence of this other party is known, saka palang tatakbo yung 4 years. Now, we have already clarified what the extent of rescission is. Kasi yun nga, rescission, to rescind, that is the root word of the word rescissible. Now, let us go to the meat of the matter. Which contracts are rescissible? Kanina, we tackled the matter of injury, damage, or lesion. There has to be an element of injury that would make an otherwise valid contract rescissible. So first one, a contract entered into by a guardian. So ibig sabihin, a contract entered into by a person representing an incapacitated party. Siguro minor, siguro of unsound mind, mga hindi kayang mag-decide for themselves under the law. So, a contract entered into by a guardian where the ward he represents, so basically si ward, yan yung incapacitated party. So, in the legal language kasi for guardianship, we have a guardian, yung nagbabantay, taking care of the affairs, and we have the ward. Yan yung incapacitated party, yan yung minor de edad, yan yung of unsound mind, yan yung insane, yan yung demented. Yan yung binabantayan, whose affairs are being taken care of by the guardian. So now, the ward here suffers lesion or damage or injury by more than 1/4 of the value of the thing, which is the object thereof. So what injury is contemplated here? Economic damage, no? Hindi naman to physical injury. All right? So probably lugi, no? Being sold at a loss to such an extent na more than 1/4, no? Yung pagkakabenta nung guardian doon sa property nung kanyang ward. So, menos ng presyo of at least 25%. Or rather, more than 25%. Rather, kasi lesion by more than 1/4. So it has to be more than 25%. So if the land, basically, for example, parcel of land priced at 1 million pesos. So ibig sabihin, ibinenta ni guardian, for example, ibinenta niya ng half the price, 500,000 pesos. So there is economic damage, there is lesion inflicted upon the minor. Kasi lugi yung pagkakabenta, 'di ba? He could have had directed his or her guardian, or rather the guardian should have exercised their discretion and sold the property at full price. Yung hindi namang ikakalugi ni minor, no? Binenta 500,000. That's lesion by more than 1/4 of the value of the thing. Now, another kind of rescissible contract is this contract agreed upon in representation of absentees if the latter suffers lesion of the same degree as the previous item. So same principle. It's just that instead of a minor, ang nire-represent ni guardian dito ay an absentee. So a person who is not present in order to handle his or her personal affairs. So paano nga naman makakapalagi? Wala siya, di ba? Tapos ibinenta ni guardian by more than at a loss of more than 1/4 of the value of the thing. All right? So gets nyo na yung idea. It revolves rescissible contracts sa matter of principle. Umiikot lang yan sa matter ng economic damage. Okay? Now, on rescission based on lesion, take note na if the contract is court-approved, we have court-approved agreements kasi. So, si korte yung nag-direct na o magkasundo kayo, party A, magbayad ka ng ganito kay party B. Party B, in exchange for the payment, you give this particular thing to party A. If the contract is court-approved, kahit na on its face parang lugi, no, parang may economic damage na nagbabadya, rescission will not be available as a remedy. Rescission, in fact, will not take place. Precisely because it is not any error or any failing on the part of the parties that causes this ostensible economic damage. It is the court, no less, which directs, no, compliance with the terms that it itself provided. So korte yung nagsabi, sundin na lang natin. Kahit na parang may economic damage, parang may lesion na nakaamba. Never mind that. Follow what the court says. Now, another kind of contract which is rescissible is one undertaken to defraud creditors when the latter cannot in any manner collect the claim due them. Okay? Remember, no? Remember yung ating hierarchy of remedies that an aggrieved party may avail of in case of breach of obligation. Of course, specific performance or collection. And then after that, diba, you go against the property. No? You go against the property of the debtor. Yun ang ibebenta para pambayad. Diba? Yun ang ibebenta para pambayad dun sa utang. Now, failing that, you go against, no? You go against the debtor, no? The debtors of your debtor. Yeah. So basically, action subrogatoria. All right? That's action subrogatoria. You subrogate yourself into the shoes of your debtor and then pursue the debtors of your debtor. Sa halip na magbayad sila kay debtor, magbabayad sila sa iyo at yung pinambayad nila sa'yo, pwedeng mag-serve as pambayad utang. Alright? And then finally, di ba yung, kung naaalala pa ninyo yung aksyon Pauliana. Basically, this action is one instituted in order to annul or nullify contracts entered into by the debtor in order to defraud the creditor. What is my usual example for this? Di ba? Alam ni debtor na hahabulin siya ni creditor in order to hold him to account, in order to demand fulfillment of the obligation, the payment of a debt. Ngayon, nararamdaman ni debtor na wala siyang masyadong liquid assets, no? Walang masyadong pera. Gayon pa man, meron siyang sasakyan na gustong-gusto niya. Now the thing is that ayaw niya naman na maremata, kumbaga, or mato, or makumpiska ng korte yung sasakyan para ibenta. Kasi he really likes the car. Ngayon, ang ginawa niya, nagpa-draft siya ng contract of sale, ng deed of absolute sale. Di umano, ibebenta yung kotse sa kanyang kaibigan. Pero actually, ang intention ay hindi naman talaga susundin yung deed of sale. Kumbaga, yung tinatawag nating pansamantagal lang, no? Or rather, pansamantala lang. And once na lumamig-lamig ang sitwasyon at manawa si creditor sa pangongolekta, ibabalik kay debtor yung sasakyan. Now, this is a contract clearly intended to defraud the creditor. You're basically allowing, no? You're basically allowing it so that the creditor would not be able to fully implement or enforce his right to be paid. Kasi yung pwede sanang ibenta para pambayad utang, tinransfer mo kuno sa ibang tao. Di umano sale, pero actually, parang dineposito mo lang sandali yung sasakyan. Until such time that tempers die down, until such time na, oh, safe na ulit, I'll be getting back my car now. So, that kind of contract is rescissible. Now, how do we know if a contract has been entered into in fraud of creditors? Now, the law provides, particularly Article 1387, the law provides for different badges of fraud na tinatawag. These badges of fraud lead to a presumption that the contract in question was entered into in fraud of creditors. Number one, all contracts by virtue of which the debtor alienates property by gratuitous title, donation, no? When the donor did not reserve sufficient property to pay all debts contracted before the donation. So basically, inubos ni debtor yung kanyang property. Donate sa kung kani-kanino. Or sa isang tao siguro. Ngayon, clearly ang intent ng donation or donations na yun would be to make it so that the creditor would not be able to set apart sufficient property para ibenta na pambayad utang. That's rescissible. Now, alienations by onerous title when made by persons against whom some judgment has been rendered or some writ of attachment has been issued. So, for example, a case for specific performance filed by the creditor against the debtor. The court ruled in favor of the creditor. Sabi ni court kay debtor, magbayad ka na. Alright, ngayon, in order to save his properties, his beloved properties, sakyan, ganyan, and other things na pwedeng ibenta, what the debtor did was to draft deeds of sale, pinagbebenta niya yung kanyang mga gamit sa ibang tao. Benta kuno. Alright? That is in contravention of the final judgment of the court. which demands compliance already with the obligation. That contract or those contracts, yung mga pagbebenta na yan, aggressive na pagbebenta para lang maitabi yung mga properties, putting them beyond the reach of the creditor, that contract or those contracts are rescissible. Now, other classifications rather of rescissible contracts. One referring to things under litigation if it has been entered into by the defendant without the knowledge and approval of the litigants or of competent court authority. So, for example, isang kaso filed before the court seeking to resolve the matter of who owns a particular lot. Si A ba, the complainant, o si B ba, the defendant? Kaso mo, ito palang si B without the knowledge of the court. And even while the case is pending, ibinenta ni B yung lupa kay C. All right? So that contract is also rescissible. Also, yung catch-all, as usual, all other contracts specially declared by law to be subject to rescission. Now, medyo madami yung provisions ng Civil Code which provide for such rescissible contracts. Now, what is rescissible payment? Article 1382 of the Civil Code provides that rescissible payments are payments made in a state of insolvency for obligations where fulfillment could not be compelled at the time they were effected. All right? Again, this kind of payment is rescissible. All right? Now, that's rescissible contracts for you. How about voidable contracts? Now, some of you might have heard of this line. Those of you in relationships, masaya naman tayo, di ba? Medyo mabigat, no? Pag mayroong nagtatanong ng ganyan sa isang relasyon, first thing that would come to mind is that something is wrong. Something is terribly wrong. Does that mean that the relationship is over? No, not really. Diba? But at most, it's an admission that something is amiss. Merong mali. Merong hindi magandang nangyayari dun sa relasyon. Which might be a ground for you to leave or end the relationship. But on the other hand, pwede mong ipagkibit balikat at sumagot na, oo, masaya naman tayo. The relationship continues in its merry way. Now, ano ang connection yan sa voidable contracts? You see, this is how voidable contracts work. Voidable contracts are valid and binding until annulled. Kung iiwan mo lang siya, ang voidable contract, it's valid. It binds the parties. In order to assail a voidable contract, you have to file an action for annulment, which we'll be going into later. Now, voidable contracts will ripen to full validity kasi valid siya, yes, all right? I want you to understand this. A voidable contract is a valid contract, but it is not fully valid in a sense that is similar to a valid contract per se. Hindi siya valid, okay? It has yet to ripen to full validity. It can only do so by ratification. So, yung tinatawag nating ratification, it can take the form of inaction on the part of the party who can contest it. So, more often than not, mayroong party, the aggrieved party, who has the capacity to question, no, a voidable contract. Now, but what if that party does not say anything? What if he holds his peace? After the passage of a particular period of time, the voidable contract will then become fully valid. Of course, if the proper party timely raises the issue of the validity of this contract, a voidable contract can be well and truly annulled. So yes, to reiterate, a voidable contract is one that is valid and binding unless annulled by proper action in court. Like I mentioned earlier, a voidable contract can be ratified. And through ratification, a voidable contract is cured and it becomes valid. Now, which contracts are voidable? A contract is voidable where one of the parties is incapable of giving consent. All right, so that's the first class of voidable contract. One of the parties is a minor, one of the parties is insane, one of the parties is a deaf mute, one of the parties, is demented. Merong incapability of giving valid consent. Now, another class of voidable contract is yung tinatawag nating merong vices of consent. A contract afflicted with the vice of consent, where consent is vitiated by mistake, by violence, by intimidation, by undue influence, or by fraud, even though there may have been no damage to the contracting parties. Damage is not required. Damage is not a prerequisite in order for a voidable contract to be said to exist. Now, let us move to fraud first and foremost. What is fraud? Fraud is when, through insidious words or machinations of one of the contracting parties, the other is induced to enter into a contract which, without them, he would not have agreed to. Panloloko, panggagancho, panlalamang. May pinasok ang kontrata because of some kind of assurance or misrepresentation. Pumasok ka sa kontrata kasi naloko ka. That is fraud. Fraud is any deceitful act. Fraud is, however, determined by the courts on a case-to-case basis. Wala tayong hard and fast rule as to what exactly is it that constitutes fraud at all times. All right? For example, back in the day, wala naman sa hinagap ng mga tao na fraudulent transactions can be entered into beyond the usual traditional methods. Back in the day, you talk to other persons personally. Kung susulat ka through snail mail or through telegram, not the app, as in literal na telegrama, the advent of the internet is a relatively recent achievement. And back when the civil code was enacted, wala pa sa hinagap ng sino man na you can defraud people through the internet remotely from the comfort of your own home. Kaya walang hard and fast rule as to fraud. Kasi every day poses a new opportunity for people to discover new schemes, new ways to fool other people, new ways to defraud other people. All right? Fraud is, of course, never presumed because the presumption, the governing presumption is in favor of good faith. Good faith is presumed. Meanwhile, fraud is never presumed. In fact, it should be proved by sufficient evidence. Yung tinatawag natin clear and convincing evidence. Of course, fraud is synonymous with bad faith. When we speak of fraud, there is always bad faith. Now, what are the requisites in order for fraud to exist? Fraud must, of course, be applied by one party upon the other. There must be here serious deception or misrepresentation. May lokohang nagaganap. The fraud must have induced the victim to enter into the contract. So, naloko yung biktima. And of course, the fraud must have resulted in damage or injury to the victim. Now, the failure to disclose facts when there is a duty to reveal them, like for example, when the parties are bound by confidential relations, merong confidential, not necessarily secret ha. Ang ibig sabihin natin dito sa confidential na to is that which is filled with trust and confidence. For example, a confidential position in government, yung mga chief of staff. That is a confidential position, not necessarily because it entails secret work. Not really, but simply because this position or the person occupying the position is, or rather has a link of trust and confidence with the boss or with the supervisor. So, merong element ng tiwala. So therefore, if there's an element of trust and confidence, kinakailangan alam ng other party yung lahat ng kailangang i-disclose. For example, a contract appointing where A appoints B to be his attorney in fact. Ang problema, for example, si B, na gustong i-appoint ni A, meron siyang sideline na merong conflict of interest tuloy as against A. So, paano yun? You have to disclose that. Na I would have to respectfully refuse the appointment or the appointment as an attorney in fact or as an agent. Kasi yung karebalo ninyo, Sir A, yung karebalo ninyo, katrabaho ko po. So there is a duty to reveal such important facts. Now, if there is a failure to disclose those facts and you ended up entering into a contract, there is fraud. Now, usual exaggerations in trade, on the other hand, these are not by themselves fraudulent, especially when the other party had an opportunity to know the facts. Yung mga, 99.9% ng germs ay matatanggal. No? Not necessarily fraudulent. Of course, the very industry recognizes those as mere exaggerations. Wala namang matinong taong maniniwala. It is only parang rekado lang. No? By themselves, hindi sila fraudulent because no reasonable person would believe that. Now, mere expression of opinion, this does not signify fraud. You're just stating your opinion after all. Unless the opinion was proffered by an expert and the other party has relied on that expert's special knowledge. For example, wanted to listen to this one. This is a commercial for Sensodyne.
Excited ako for the advanced science behind the new Sensodyne Repair and Protect that gives deep protection.
Let me pause that. Napapansin ba ninyo sa mga commercials? Tingnan ninyong mabuti in particular yung mga commercials para sa toothpaste, yung mga commercials para sa sabon, yung mga commercials para sa mga beauty and health products basically, para sa mga hygiene products. Yung merong mga doktor so and so na nagsasalita in favor of these products. Ang pinakaano talaga nito, ang pinakasalary nito, either toothpaste o gatas. Especially yung mga gatas para sa mga gifted child in order to promote, in order to promote the concept of giftedness. Tatalino ang anak nyo pag ininom nyo itong gatas na to. Ngayon, tingnan nyo to. The commercial here, itong si Sensodyne, napakahilig nitong magkayag ng doktor. But as you can see, itong si doktor na to, hindi naman siya talaga Hindi naman siya talaga presented as an expert. This is a gray area which, ad agencies and many companies tend to, take advantage of. Like for example, how can you say that this guy right here is being presented as an expert? Na kung saan, kapag naniwala ka sa kanya na maganda nga tong toothpaste na to, tapos hindi naman gumana according to how it was advertised, di syempre, sasabihin mo ba na umasa kasi ako dun sa I relied on what this Dr. Huang said. But as you can see, hindi naman siya presented as an expert. Clearly, he is a fictional character. Tingnan ninyo. Number 1, wala siyang first name. Who the hell is this certain Dr. Huang? Are we even sure that this guy is a real doctor? Or he's just acting out a role, no? As is the norm when it comes to commercials. Tapos tingnan pa ninyo to. How can he be considered an expert in the Philippines when he is a registered dentist in Taiwan? You see the gray area there? So sabihin natin merong hindi satisfied kay Sensodyne. Hindi niya pwedeng sabihin na nag-rely siya doon sa representations nitong di umano'y doktor na to, nitong dentista na to. Alright? Now, let us continue a bit.
Ito ay proven and effective. With its new Novamin formula, tumutulong ito mag-protect deep inside sensitive teeth, forming a protective layer. Kakaiba to. It really works.
O, di ba? Kakaiba to. It really works. Pero, again, hindi siya presented in the context of an expert. Nasa saan yung peer-reviewed na proof? Di ba? Hindi siya nagva-violate per se nung prohibitions under our civil code which pertains to experts. Because there is no way in hell, ang gagawing depensa niya ni Sensodyne, there is no way in hell that this Dr. Huang can be considered as a believable expert in any stretch of the imagination. Now, what if the misrepresentation is not from a party to the contract, but by a third person? All right? Misrepresentation by a third person does not vitiate consent unless, number 1, such misrepresentation has created substantial mistake, and number 2, such mistake is mutual. All right? Yan ang sinasabi ng civil code on this. Now, no? Ano ang implication nito? What does this mean? Let me give you an example. All right? 1342 of the new civil code. A owns a car worth 800,000 pesos. All right? Following me so far? Now, A sold the car to B for only 300,000. Paano nangyari at ibinenta ni A kay B yung sasakyan, which is, worth a substantial sum of money, pero binenta niya for such a low price? That is because C misrepresented to A that his car was only worth that low. All right? This is not fraud unless mapapatunayan that C connived with B. Na sinabi ni C kay B siguro na tingnan mo to. Kukumbinsin ko yan si A. Papapaniwala ko yan na mababa lang ang presyo ng sasakyan niya. Tapos pag binenta niya sa'yo, you will see. You will see. So if there is connivance, then that can be considered as a, how do we call this? As a vice, no, of consent that will lead to the contract being not merely valid but outright voidable. Now, misrepresentation by a third person may give right to an action for damages against the person who did the misrepresentation. Now, if the third person acted in collusion with the party who benefited thereby, number one, the injured party may annul the contract. So annulment is always in the works. No? Annulment can always be resorted to. And secondly, the third person and the party who benefited are solidarily liable as against the injured party. Now, misrepresentation in good faith is not fraudulent. So, ang paniwala, for example, ni seller na yung kanyang sinasabi ay tama, no? Without knowing that it's actually a statement that misrepresents the thing, no, which is the object of the contract. However, it might constitute substantial error, which is, well, tantamount as well to vitiated consent. Ganon din, no? Which would lead to the contract in question being declared as voidable. So stop muna tayo dyan.